Subcommittee will come to order, and good afternoon to everyone. I want to thank all of you, especially all of the left-behind parents I see in the audience, for joining us this afternoon to discuss the continuing crisis of international parental child abduction. Today, there is hope that the new administration will change the status quo. There is hope that the Sean and David Goldman International Child Abduction Prevention and Return Act will finally be enforced. And there is hope for those of you who seek to be reunited with your children that a better day is coming. As many of you here today have experienced, international parental child abduction rips children from their homes and whisks them away to a foreign land, alienating them from the love and care of the parent and family that is left behind. Child abduction is child abuse and continues to plague families across the United States. According to the State Department's statistics, approximately 1,000 children are today held hostage in a foreign country, separated from their American parent. Several hundred additional children join their ranks every year. Based on historical trends, less than a third of these children will ever come home, unless, of course, the Trump administration decides to do what the previous administration did not do: change tack and stand up for the American parents and children using the full, I repeat, full array of tools prescribed by the Goldman Act to help achieve the necessary objective. I was heartened to hear that many of you visited the White House this morning. This is a good sign and give rise to the expectation that your voices will be heard. Indeed, I join you in imploring President Donald Trump to act, and to act decisively. For decades and throughout the Obama administration, the State Department has used quiet diplomacy to attempt to bring these children home. In a hearing that I chaired back in 2009, then Assistant Secretary of State Bernie Aronson called quiet diplomacy, and I quote him, a sophisticated form of begging. Thousands of American families are still ruptured and grieving from years of unresolved abductions, confirming that quiet diplomacy alone is gravely inadequate. In 2014, after 5 years of persistence, Congress unanimously passed the Goldman Act to give teeth to requests for return and access. The actions against non-cooperating governments required by the law, escalating gravity, and range from official protests through diplomatic channels to the suspension of development, security, or other foreign assistance. Extradition of abducting parents also may be called for. The Goldman Act is a law designed to get results, as we did with the return of Sean Goldman from Brazil in 2008. Brazil's participation in the generalized system of preferences is up again for renewal this year. Why should Brazil get billions of dollars in tariff relief when their courts have not returned a single child since Sean Goldman? We have 13 long-term cases pending there, including the particularly egregious Dr. Braun and Davenport cases. It's time for action and fully taking advantage of our leverage. More than 90 American children are separated from their American parent in India. The many years required to resolve such cases in India make it a magnet for abduction cases and crimes. These numbers will continue to climb each year until India creates a mechanism for resolution of current cases or joins the Hague Convention for future cases, which to date it has refused to do. Thinking outside the box as to what leverage to apply, India's visa allotment could be reduced every year if it is non-compliant in the return of abducted American children. But there are many, many options on the table, and again, so many that were prescribed by the Goldman Act. Japan is another country which is a flagrant violator. American service members whose lives are on the line protecting Japan are some of the victims. The Obama administration's indefensible refusal to use the sanctioning tools embedded in the Goldman Act has been noted by other governments and is hurting American children. On February 14th, for example, Valentine's Day, Japan's Minister of Foreign Affairs, Fumio Kishida, noted that in their parliament, the Diet, that, and I quote him, until now, There is not a single example in which the U.S. applied Goldman Act sanctions toward foreign countries. Let me repeat that. Until now, the foreign minister has said, there is not a single example in which the United States, U.S., applied sanctions, Goldman Act sanctions, toward foreign countries. That is outrageous, and that has to change. 3 days later, the Osaka High Court overturned a return order for 4 American children to James Cook, who will testify today, in flagrant violation of the Hague Convention, Japan's own Hague Implementation Guide, and United States law. Japan fears no consequence, had no fear of consequence under the Obama administration, and thus our children are left behind. Parents and their parents suffer the pain of separation. The Elias family is here today, have been waiting 8 years to even speak with their children after a flagrant abduction in which the Japanese consulate was an accessory. I traveled to Japan with the grandmother, and I can tell you, she tried, as has Michael, over and over and over again to even have access to their kids, his kids. And again, there has been a closed-door policy. We need to apply the Goldman Act sanctions to Japan. Yes, they are a friend and an ally. All the more reason. Friends don't let friends commit human rights abuses. When is Dr. Friciato, who is, again, one of our witnesses today, has been waiting 7 years for Slovakia to enforce the return for his children. Matter of fact, he says in his testimony, is enforcement of U.S. law optional? Why is it that we have not had the full, all-out enforcement of the United States law under the Obama administration? I hope and I pray, and we will press, that the new administration will not continue that pattern of indifference. When is enough enough? What we need is a change in the culture of the State Department, which too often rewards Foreign Service officers for appeasing countries in the name of maintaining harmonious relations. And frankly, I've been on this committee for 36 years, in Congress now 37, so I've been on it for 35. And I can tell you, I travel, we have very fine people who serve as Foreign Service officers, but when you rock the boat, when you stand up for Americans, that's not a career enhancement process for you. That has to change. So the culture of the Department of State has to change. Implementing the Goldman Act fully and robustly will send a message to allies and foes alike that the United States means business about ending the suffering of American families, and we mean business when it comes to these children. Dr. Hunter, I thought, and she will lead off our testimony today, in her opening paragraphs makes just a very, very profound statement that this Congress and this administration represents our best opportunity ever to put America first for America's stolen children and make the return of American children to the United States a priority. I want to thank her and all of our witnesses for your testimonies. Without objection, they all in their fullness, and any additional information you would like to add will be made a part of the record. We're joined by my good friend and colleague, Mr. Garrett. I'm not sure, would you like to?
Briefly, Mr. Chairman, I just want to thank you and recognize you for your 35-year commitment to causes such as this in this body. I tell people oftentimes, Mr. Chairman, that sometimes you find your passion and sometimes your passion finds you. It's been my great honor for just these few months to serve on this subcommittee with you, and these are issues that all too often are unheard by the American public, and it's something that we've sort of, as you know, dove headlong into, and it's just an honor to be able to work with you for such a great cause with people such as yourselves. Please, I welcome anyone in the gallery to contact our office as it relates to concerns that you may have so that we can leverage whatever little power we have to yield to help to have the return of our children to their families in our nation. And thank you, and I yield back the remainder of my time.
Mr. Garrett, thank you very much, and thank you for your service to our country, the armed services, but also for stepping up on a variety of human rights issues so early in your tenure as a member of Congress. I'd like to now introduce our distinguished panel, beginning first with Dr. Noelle Hunter. who is the Executive Director of the Kentucky Office of Highway Safety and has been in that role since June of 2016. In 2014, Dr. Hunter testified before the U.S. Senate Committee on Foreign Relations on the problem of international parental child abduction. She successfully recovered her daughter from abduction to Mali that same year with the support and resources from her home community of Moorhead, her native state of Alabama, and from Congress, the U.S. Department of State, and the U.S. Department of Justice. She co-founded I Stand Parent Network to empower parents to return their children from abduction and currently serves as president of the board of directors. Thank you, Doctor, for being here. I then will turn to Mr. James Cook, who's the father of 4 children, 2 sets of twins, who were abducted and are now in Japan. In this time, he has only been allowed 1 visit with his children and has not been allowed any access to them since August of 2015. Mr. Cook works for Boston Scientific Corporation, a manufacturer of medical devices in Minnesota. Mr. Cook testified before this subcommittee last July of last year, and again, we welcome him back and look forward to updates and insights that he can provide. We'll then hear from Dr. Augusto Frizancho, father of children abducted to Slovakia. He is a physician and received his medical degree in general medicine from Charles University in Prague in the Czech Republic. He works at Johns Hopkins University in Baltimore in public health, medical research. He also works for the National Center for Missing and Exploited Children as a consultant, providing support to families impacted by a missing child. His 3 children were abducted to Slovakia by his wife in 2010. Then we'll hear from Mr. Vikram Jagtiani, whose daughter, Nikita, was born in New York, taken by his wife in 2013 when she was just 4 years old. Wanting to see his daughter again, he co-founded Bring Our Kids Home, along with other left-behind parents whose children have been abducted to India from the United States. Bring Our Kids Home seeks to raise awareness about international parental child abductions community and advocate for the prompt return of all American children. Dr. Hunter, the floor is yours.
Good morning. Good morning. Thank you, Mr. Chairman. Thank you, Mr. Garrett, for making the opportunity to attend today. We have just recently come from the White House, myself and my fellow parents. It was a very productive meeting. We were very candid about the concerns that we have about current enforcement of the Goldman Act, but more importantly, there is an opportunity here to put America first for America's stolen children. I am honored to share my story and speak for fellow parents of internationally abducted children. As you said, sir, this Congress and this administration represents our best opportunity ever to put America first for America's stolen children and make the return of America's kidnapped children a priority to the United States. I am president and co-founder of I Stand Parent Network. My daughter, Muna, was a victim of international parental child abduction. She was abducted from our home in Moorhead, Kentucky on December 27, 2011. She was only 4 years old at the time and taken to Mali, West Africa by her father. Despite some initial delays, I soon had court orders for her return and cases with the FBI, the Department of State's Office of Children's Issues, and the National Center for Missing and Exploited Children. My experience with all of these agencies was exceptional, responsive, and accomplished the goal. Sadly, this is not most parents' experience. Most parents find the return of their children is subordinated to not making nations feel uncomfortable. Mali initially showed no interest in working with me or our government to return Muna. That all changed in November 2012, the day I staged a protest in front of the Mali embassy here in Washington and subsequently engaged my congressional delegation, including Senate Majority Leader Mitch McConnell, Senator Rand Paul, and Chairman Hal Rogers. I'm grateful that Muna's case became very personal for Senator McConnell and Chairman Rogers in particular. They constantly engaged with the Department of State, Department of Justice, and Malian officials in Washington and Bamako. Chairman Rogers raised our case directly with former Secretary of State John Kerry during an appropriations hearing. Senator McConnell progressively escalated his interactions with the nation of Mali while receiving regular updates from the State Department. I was blessed to have benefited from a whole government response, and that is the reason that Muna is home today. Just before she came home, as you said, sir, Senator Corker invited me to testify on the Goldman Act, legislation that was supposed to make life easier for parents who are trying to return their children before the Senate Committee on Foreign Relations. And of course, Mr. Chairman, you have been our champion all along, drafting and shepherding the Goldman Act till its eventual enactment. And I believe I speak for all of the parents when I say that we thank you. You give us hope that our children can come home. This is all the momentum that I took with me to Mali in the summer of 2004. U.S. Ambassador Mary Beth Leonard and consular officers facilitated a meeting with Mali's Minister of Justice, and that day I knew that I was coming home with my daughter. We were escorted out of the country by the United States Marines, and Ambassador Leonard herself put us on the airplane. When we arrived at Northern Kentucky Airport, my beloved Senator McConnell was there to welcome us home. I'm told that my story is unique, and sir, this is tragic. It should not be this way. If every member of Congress with kidnapped constituents would begin to regularly inquire of federal agencies and the nations in which they are held, and also require enforcement of the Goldman Act and other laws that are designed to make it easier to bring our children home, we would see an immediate surge in returns and reunifications of children with their parents. A whole-of-government support of parents who have had their children stolen from them would also create a very strong deterrent for would-be abductors and put nations on notice that America will not tolerate the theft of its children. There are a few things, sir, that need to happen to hasten those outcomes and make my story less unique. The Trump administration has a golden opportunity to show parents across these United States whose children have been kidnapped to countries that actively work against their return that it supports these parents and will do all it can to bring our children home. As I said, I was blessed to have the active involvement of the Kentucky Congressional Delegation, the Department of State, and the Department of Justice, including in the Department of State Ambassador Leonard and embassy staff in Bamako. But every tax-paying parent, every single one in the United States, deserves the full-throated, aggressive support of our government. The Trump administration has a chance to signal its intent to support American parents where prior administrations have failed to do so. America first must mean putting America's stolen children first. Countries around the world that are harboring American children and ignoring their legal obligations need to be put on notice that it is time to comply. The worst offenders in the international community, countries like Brazil, India, and Japan, need to be more forcefully addressed and not given a pass by diplomats. Laws need to be taken seriously and enforced, and there need to be consequences for failing to adhere to international obligations and other commitments. And in circumstances where countries still refuse to return our children, they should no longer receive the benefits from the United States, such as favorable trade agreement, visas, and foreign aid, until they do comply. Case in point, Brazil, as you mentioned earlier, has aided and abetted the kidnapping of many American citizen children. But the United States government has, to date, failed to take this issue seriously, and Brazil has responded accordingly. If Brazil does not start returning children to the United States quickly and make other good faith efforts to show that it intends to return all American children, the United States has an opportunity later this year in 2017 to deny Brazil the over $2 billion benefit it receives by taking part in the United States Generalized System of Preferences, or GSP. Brazil must literally pay a price for noncompliance here, and the GSP represents a perfect opportunity to demonstrate seriousness. Similarly, India has aggressively refused to return American children, but the president has the authority to prevent H-1B visas and other lucrative work visas from being issued to an Indian national if it does not start returning American children. India, too, can be forced to pay a price. The Department of State must prioritize the return of American children over diplomatic niceties. It is understandable that diplomats believe in success through dialogue, but when it comes to international parental child abduction, let's be clear. The goal is not dialogue, but the return of abducted children, period. The Department of State needs to be refocused on what is most important, putting America's children first. Dialogue is a means to an end and not an end itself. Transparency with the Congress and the American people is essential. The Department of State definitively has the capability to report specific data to Congress to inform your casework, legislation, and oversight. It has the data collection and analytical tools necessary to report abductions by state and plot abductor destination countries on a world map. Despite this capacity, the Department of State has respectfully made a concerted effort to keep the scope of this problem hidden, particularly during the previous administration, and it did so for one very important reason. It was terrified that Congress might not only have a fuller understanding of the scope of this problem, but that Congress, might also have more tools to bring many of these children home. The State Department can improve its forthcoming report by drilling down on this data and making it publicly available. Federal laws, both civil and criminal, must be enforced. Enforcement of the Goldman Act and other federal laws that are supposed to help parents is the way forward. It directs progressive sanctions against worst offender nations who benefit from economic, cultural, and diplomatic relationships with the United States and yet refuse to return our children, hold them captive. The Department of State needs to stop issuing demarches, diplomatic wrist slaps behind closed doors, and start using the full array of tools outlined in the Goldman Act, including sanctions against non-compliant countries, in order to be most effective. And the Department of Justice has options that can and should be considered as well. While many abducting parents do not generally leave the country where they have taken their abducted children, some do. In fact, some own property and assets internationally, including in the United States, and even travel for business, sometimes frequently. Each of these international assets and points of travel is a point of leverage for abducting parents and should be actively explored. International agreements governing international child abductions must also be enforced. The Hague Convention on the Civil Aspects of International Child Abduction, which is the governing treaty for international parental child abductions, does work for some, and we are aware of a handful of cases, comparatively speaking, of children who have come home by this process. In fact, I just learned of a parent whose son was abducted to Italy who recently came through a Hague return order. We are very happy anytime a parent and child are reunited for whom this process is working. But I am, in a minority of successful cases. The aforementioned nations and other states parties which acceded to the Hague Convention and yet declined to enforce access or return of children to their habitual residence in the United States under that convention must be held accountable. Finally, there must be a persistent, whole-of-government approach to bring children home. For nations like Mali, which is not a signatory to the Hague Abduction Convention, there must be pressure and insistence on returns. Though it was never said to me, sir, I am quite certain that Mali was becoming distinctively uncomfortable with the level of attention by me, MUNA's supporters, and my government. The United States government, which would not let my daughter be lost. I am confident that other nations would follow suit as Mali to let these children go should they come under greater scrutiny. We can see the results in every country that is harboring abducted children if every presidential trip, every diplomatic delegation, every congressional delegation raises the crisis of our children when visiting these countries. More children will come home once these countries understand that we are not going away and we will not forget our children. What matters most is that we stand united for their return. For Hannah and Ryan, Eslam and Xander, Mochi and Keisuke, Rayansh and Rachel, Eliav and Abdallah, Gabriel and Anastasia, Henry and Helena, and all of America's stolen children. May we not rest, may this country not rest until the banner of liberty and freedom that we enshrine and believe in is extended over them to usher them home. Thank you, sir.
Dr. Hunter, thank you so very much for your testimony and for laying out a number of very, very important ways forward. Thank you.
Thank you, sir.
Mr. Cook.
Thank you, Chairman Smith, members of the subcommittee, and members of the audience watching these proceedings all over the world. I really appreciate this opportunity to speak to you a second time about my Hague Convention case in Japan and the problems encountered following the previous testimony given last July. First, I want to say hello to my children because I have not been allowed any access to them since August 2015. This is in direct violation of Hague and evidence of Japan's continuing noncompliance. Hello, children. I have not and will not give up having us together again in the USA. I am sorry this situation has not been resolved by now. I am closer than ever before to having us together again. Please hold on. Love, Dad. There were 2 failed Hague return enforcement attempts in Nara, Japan in September 2016. Direct enforcement was done exactly as Japan requires, an almost SWAT-like ambush where they were living. During the direct enforcement, I was only able to hear the voices of my 2 older sons, and I did not recognize those voices. It was a sobering reminder of how much has been missed. As a parent, to be unable to recognize your own child's voice brings a type of pain that cannot be described, but certainly can be felt as a visceral shudder by all present parents. At the direct enforcement attempts, there were court officers, police, psychologists, and officials from the Japanese Central Authority and U.S. Consulate. With the exception of the U.S. officials, it was obvious that everyone else was there to protect the children from me trying to see them and to thoroughly document an anticipated, calculated failure. I foolishly thought these officials I had paid to execute direct enforcement were there for my success. In reality, they were just playing their roles, a predetermined outcome, failure. Furthermore, and worst of all, it severely traumatized our children in a way that did not need to happen. With the unsuccessful enforcement attempts, Japan has once again failed to enforce a Hague return order. This time, it was the one issued by the Osaka High Court on January 28, 2016. This indicates a systemic problem that was also reported in the annual Hague Compliance Report issued just a few days prior to my last testimony in July 2016. This is 2 years in a row that Japan has been unable to enforce its Hague return orders. This is a systemic problem and should be concerning for any foreign entity planning to enter into contracts or binding agreements with parties in Japan. It certainly should concern foreign governments regarding allowing any of their children to visit Japan. Assumption of subject matter jurisdiction in accordance with the Osaka High Court return order dated January 28, 2016, and a mirror return order were issued from Hennepin County Family Court in Minnesota on December 2, 2016. Then again on December 13, 2016. And then again on January 24, 2017. And then again on March 24, 2017. And then a very thorough analysis of continued subject matter jurisdiction and return order on April 4, 2017. Will Japan even respect our court's rulings as we are expected to respect theirs? I was granted temporary sole custody, and our children and they were returned, or they were ordered released to me on December 17, 2016 at the U.S. Consulate in Osaka for their return to the United States. Our children were never brought to the consulate on that day. In violation of 2 Minnesota court orders, Hitomi Adimitsu was in contempt of the Minnesota court orders that mirrored the Hague return order of Japan. I take a moment here I must acknowledge the significant efforts and resources that were put forth and put in place for that day by the Department of State. And fortunately, it did not turn out as we wanted it to, but I thank everyone because a great amount of effort was put forth, and I appreciate that. After a year of unsuccessful enforcement, on January 5, 2017, Hitomi Adimitsu filed for a modification of the Osaka High Court return order citing grave risk standard under Hague. The evidence of grave risk cited was of relative lifestyle change if returned. On February 17, 2017, the Osaka High Court Hague return order of January 28 of 2016 was revoked, and at this time, our children are not being ordered returned by the Osaka High Court. The revocation of previous return order indicates invalid interpretation of the Hague Convention and provides further evidence of Japan's failure to comply with its international obligation. Article 28 of the Japanese Hague implementing legislation enables an expanded interpretation of grave risk that gives judges broad leeway, way beyond international precedent and language of the Hague, to deny returns. In this instance, it overturned their own previous ruling and, in effect, made use of the taking parent's ongoing noncompliance with a Hague return order in Japan and from the habitual residence of the children in Minnesota. Article 28 is not compliant with the Hague, and it must be changed by fellow Hague signatories. The February 17, 2017 order was signed by Presiding Judge Toru Matsuda, Judge Yoshinori Tanaka, and Judge Takahiro Hiwara. We have appealed this ruling to the Japan Supreme Court, and we received permission on March 29th to have our case heard. According to my attorney, it will likely take up to 1 month for the Supreme Court to receive the file from Osaka High Court. If the February 17th decision is overturned, as we fully expect, it will take an additional 6 to 12 months for a Supreme Court hearing. The projected timeline far exceeds the expeditious processing of Hague cases as outlined in the Convention. My case began in August 2015, and it's still unresolved. Japan, in yet another way, is not compliant with Hague. On March 24th, Hennepin County Family Court found Hitomi Arimitsu in constructive contempt of all previous orders. As part of her purge conditions, Hitomi Arimitsu must return to U.S. or release our children to me on April 23rd at the U.S. Consulate in Osaka. Tomorrow, April 7th, Hitomi Arimitsu must surrender all passports of our children to the U.S. Consulate in Osaka, Japan, or communicate to the Minnesota court her intention to comply with the April 23rd order. On Monday and Tuesday, April 10th and the 11th, the G7 Ministerial Foreign Affairs meeting will take place in Lucca, Italy. I hereby respectfully request that our Secretary of State, Rex Tillerson, brings the topic up during this important G7 meeting in order to have it subsequently discussed in the upcoming G7 summit that will be held in Italy on May 26th to the 27th. Considering the 2 Italian children abducted and abused in Nagasaki shortly after moving to Japan in order to avoid Hague Convention proceedings, it's also in Italy's best interest to have this issue resolved before it's too late. The same goes for the other cases that each one of the G7 countries has pending with Japan. Yes, every G7 country has abduction cases that are going unresolved, and Japan stands in the way of these children being reunified with their parents. Kidnapping should not be a protected societal value. 5 days prior to April 23rd order return date, Vice President Pence will visit Japan on April 18th and 19th. He will meet his counterpart, Japanese Deputy Prime Minister Taro Aso. Vice President Pence will surely meet Prime Minister Shinzo Abe and the Minister of Foreign Affairs, Fumio Kishida, as well. I hereby respectfully request that Vice President Mike Pence speak with these Japanese officials and ask them to have Japan meet their international obligation to comply with the Hague Convention and return our children to their habitual residence in Minnesota. Excuses may be offered why they cannot, but I know from 30 years of involvement with Japan, Japan will force the return if required or given no other choice. The following day, April 20th, Italian Prime Minister Paolo Gentiloni will meet with President Donald Trump right here in Washington, D.C. The significance of this is also related to the upcoming G7 summit. The host country has determining influence in setting the agenda of the G7 summit, and considering that citizen safety is the #1 topic among the official priorities set by Italy for the G7 summit, with a target area of managing human mobility, we would like to officially request to have child abductions in Japan, a form of human trafficking, discussed and included in the agenda. I hereby respectfully request that President Donald Trump and Prime Minister Paolo Gentiloni talk about Japan's non-compliance with the Hague Convention and resolve to put the issue on the G7 agenda. Japan's continuing failure to comply with international standards puts children in all G7 member states at risk of being abducted with no feasible means of recovery. Japan remains an ongoing international threat to our children and their human rights. They are by all means victims of an outdated legal system. It is an opportunity for President Trump to demonstrate America first by demanding Japan respects a properly rendered decision and several return orders from a U.S. court. There is no viable legal means at present to recover children through the Hague Convention if the taking parent in Japan refuses to cooperate with court orders, as I know well, and there are no consequences in Japan for contempt. Our children remain with Hitomi Arimitsu in contempt of courts in both countries, aided and abetted by Mr. Yukinori Arimitsu of Arimitsu Industry Company Limited of Osaka, Japan. I wonder if anyone in Japan has influence over Mr. Arimitsu to persuade him to end this conflict between Japan and USA. Why would he want to put the country of Japan in jeopardy any longer? Hitomi Arimitsu owes me approximately $95,000 in unpaid legal expenses and fines that have accrued since the time they were imposed by the Japanese legal system. The money remains uncollected owing to Japan's dysfunctional legal system. I wonder how any foreign party or government can feel their legal rights will be protected in Japan. There exists ample evidence of a dysfunctional judiciary generating capricious rulings based upon pragmatism of situations, not principles of existing law. There are good people and groups in Japan pushing for children's rights and Hague compliance. For example, Japanese Diet Representative Kenta Matsunami on March 8th of this year repeatedly asked Japanese Minister of Justice Katsutoshi Kaneda whether he agreed with the interpretation of the revised Japanese Civil Code Article 766 given by his predecessor, Satsuki Eda. At the time of those deliberations in the Judicial Affairs Committee, Mr. Eda stated that Article 766's meaning was to disqualify an abducting parent from custody preference. After a long-winded evasion of the question and repeated questioning by Mr. Matsunami, Mr. Kaneda was finally brought to respond in the affirmative in English, yes. Likewise, Director General of the Japan Supreme Court of Family Division, the Honorable Hitoshi Murata, acknowledged the statement of his predecessor at the time in 2011 when the revision of the Article 766 was being deliberated that the best interest of the child should be considered, and this has not changed since. The revised Article 766 was designed to prevent abducting parents from retaining custody of their abducted children or gaining an advantage in court. Article 766 took effect 5 years ago and has been ignored by an unaccountable rogue judiciary mired in tradition ever since. On the same day the Hague Convention went into effect in Japan, April 1st, 2014, the current Chief Justice of the Japanese Supreme Court, Ichiro Terada, assumed office as well. He issued a statement that in translation reads, I quote, It becomes common for the courts to deal with cases which have to be considered domestic matters and international matters as the Hague Convention having come into effect today. So, I believe that we judges are asked to make sustained effort to meet the expectation and trust of the people in us and to tackle these matters by studying the real state of affairs happening in Japan and the international trend in order to strengthen the function of the judicial branch. Shouldn't Japanese courts be following both the principle of the revised code, Article 766, their domestic law, and the principle of the Hague Convention, their international obligation? In actuality, both legal standards are in abeyance in Japan. Japan's courts are not even functional for Japanese. A case in point involves Mr. Yasuyuki Watanabe. Mr. Watanabe has battled in court many years to see his child. In an unprecedented decision, Matsudo Chiba Family Court awarded Mr. Watanabe, a father, custody of their child, taking it away from the mother. This decision was appealed to the High Court on January 26th of this year, and the High Court overturned the previous decision in Matsudo. The High Court ruling explicitly cited the old discarded legal standard, the continuity principle, a principle that rewarded the abducting parent with custody in order to not upset the child. The court ignored the 5-year-old Article 766, the current law. Mr. Watanabe is appealing this errant ruling to the Supreme Court in Japan. Please note, joint custody is not a legal option in Japan, only sole custody. It's a zero-sum game in which the child is guaranteed to lose every time. This abduction appears to have been well organized and well planned. We can see there is such activity by groups in Japan as described in Liberal Time article about ShelterNet. There is also organized activity by radical left activists and communists in Japan. I believe these groups and their followers in Japan's judiciary were responsible for the non-compliant ruling of February 17th. With more international pressure on Japan, groups such as these will be exposed and brought out of the shadows. Now, I'm required to go to the U.S. Consul in Osaka for a second time to wait for our children to be released to me on April 23rd. Will the request by Vice President Mike Pence make a difference? Will Prime Minister Shinzo Abe, Foreign Minister Fumio Kishida, and Minister of Justice Katsutoshi Kaneda respond in kind and facilitate the return of our children? I urge the Bureau of Consular Affairs in its annual Hague Compliance Report due by law on April 30th to reflect the failure to enforce Hague return orders once again in Japan Country Report. Moreover, I urge the report to finally categorize Japan as a non-compliant country. Then, as indicated in the Goldman Act, Secretary of State Rex Tillerson ought to use his discretion to implement the most pernicious executive actions available to him by law, and specifically extradition of our children and Hitomi Arimitsu to USA to appear in Minnesota court as repeatedly ordered. Secretary Tillerson possesses the character and stature to resolve this issue. At a forum of the international community in which Japan takes part, this issue must be addressed at the G7 summit in Italy. Other G7 members must demand immediate changes to Japan's dysfunctional legal system and laws in order for Japan to be considered worthy of continued membership. It used to be G8, and it may be time for it to become G6. In closing, I'm here alone, but my voice represents not only my children and I, but hundreds of thousands of children, Japanese and foreign, that every year lose access to one parent in Japan. Japan has been complicit in ongoing retention of our children and failure to enforce several court orders. Parental abduction is a penal crime in most advanced countries, but in Japan it is not. Japan cannot be trusted moving forward to voluntarily take steps necessary to effect functional enforcement of court orders of any kind, specifically Hague. The tools exist in the U.S. Code to motivate Japan to comply. It's not a matter of ambiguity. The bright line has been blurred to suit others' interests, not the U.S., in the past. The Goldman Act provides a process and consequences in these situations. Within the Goldman Act, there are a myriad of consequences to choose. The power to choose and impose these sanctions resides in one office, one official, one individual, Secretary of State Rex Tillerson. Thank you again for this opportunity to speak before this committee. And I've tried to keep my testimony brief because I understand committee members have family and perhaps even children they expect will be there when they return home.
Mr. Cook, thank you so very much for, again, laying out your own case, but also with some very, very doable recommendations. And with the G7 meeting coming up, I think that's a tremendous opportunity for us to really rally with letters to both Pence, Vice President Pence, the President, and to Rex Tillerson. So I think your points were extremely well taken. Dr. Frishancho? Thank you.
I would like to say how this nightmare started. In 2008, my wife asked me for a divorce. I totally refused, and I told her we couldn't do this to the children. She told me, you could give your life for your children, but not for me. This is how you men think. When there is no longer love in the marriage, all you men want is to stay together only because of the children. I asked her to try work things out, seek professional help, get counseling, but nothing worked. After a year, I accepted it. I did apologize to her for trying to keep our marriage alive. We agreed on joint custody, and I accepted her petition to go and together tell our children that we both have decided to divorce. However, we're still married. Slovakia. In 2010, my wife abducted our children to Slovakia. I filed an application for the return of the children under the Hague Convention on the Civil Aspects of International Child Abduction. My wife was called upon by the Central Authority for the Hague Convention in Slovakia to discuss the peaceful return of our children home. When no agreement could be reached, the case was sent to the Slovak court for Hague legal proceedings that continue to this day. My wife acknowledged in court that the children loved their father, and at the end, the Slovak courts ruled the return of the children to the United States, but they never enforced it. A court order that was once final and binding was reopened later, and the case continued to this day. Travel ban. The Slovak courts also prohibited the removal of our children outside Slovakia until the Hague proceedings were finished. But my wife, in violation of that travel ban, removed our children to Hungary. European Court of Human Rights. Later on, I filed a complaint against Slovakia under the European Court of Human Rights in Strasbourg, where a chamber of 7 judges anonymously ruled that Slovakia had violated my human rights as a father with respect for my family life. And it ordered Slovakia to pay me damages. This court concluded that there was no dispute that the relationship between the father and his children was one of family life. The Slovak ruling can by no means be said to have been in the children's best interest. So where are we now? 3 judges in the United States, 4 in Slovakia, and 7 judges in Strasbourg, a total of 14 judges, men and women from different backgrounds and countries, all have acknowledged that the abduction of our children is wrong. However, the Slovak courts have stayed the Hague proceedings on the mistaken presumption that Slovakia has no longer jurisdiction, and currently the Slovak Constitutional Court is reviewing my appeal. Slovakia needs to comply with not only with the Hague Convention, but also with a European treaty called Brussels II that gives Slovakia the tools to order again the return of the children to the US and enforce that order in Slovakia in the event that the children are found in Slovakia, or to cooperate with any other country member of Brussels II, such as Hungary, to have the Slovak court order enforced in that third country. How can we start a new litigation in Hungary when Slovakia has already accumulated evidence during 6 years? Criminal charges. To top all that injustice, my wife is trying to file in Slovakia criminal charges against me for unpaid child support for children who, according to the Slovak courts, say no longer reside in Slovakia. I have said in the past that by doing that, I would be supporting this emotional abuse of the children. And moreover, it is the US court that has jurisdiction over the children. This court has given full custody, legal and physical, to me, and it says that child support will be decided by the Baltimore court, not by Slovakia. Access to my children. I have repeatedly obtained court rulings ordering the mother to allow children to meet with me. I traveled multiple times to Europe. In 1 year alone, I took 14 weeks off from my work, trying to stay in touch with my children. With the court orders in my hands, I went to my wife's parents' house. And my children's grandmother, Mrs. Piroshka Kish, told me, "Don't you know, Augusto, that you will never see the children again? Go away. Stop bothering us." On another occasion, I filed a missing person report in Slovakia, but not even the law enforcement would help me see the children. I went to their schools repeatedly in both Slovakia and Hungary, met with the teachers and principals who introduced me to my children's classmates in their classrooms, but I couldn't see the children. I never saw my children because my wife had taken them away for days and weeks until she learned that I had returned to the United States. The courts also ordered my wife to let me Skype, email, and talk over the phone with our children, but she declared openly in the court that she didn't have a computer, she didn't have internet, and she will never see me see her children anyway. My boys need me. Every boy needs his father. They are teenagers, their bodies and minds are changing from boys to men. Besides being father and sons, we were friends. We had a very strong, respectful, and very much attached and loving relationship. When my wife stayed at work from early morning to late evenings, our children stayed with me all day long. I did everything with them, woke them up, got them ready to school, gave them breakfast, made lunch boxes, drove them to school. Then I ran to work and left my job earlier in order to pick the boys up from school. Then we had lunch, rested, played, did sports. Then we went home back, and while the older boys were doing homework, I did art, drawing with Ryan, my little son. Then we had dinner together, showered before going to bed, prayed, and read before sleeping. And once the lights went off, I would tell them stories until they fall asleep. Once it happened that while I was talking to them about life and that one day we will go to heaven, one of my boys asked me, "But Daddy, why do we have to go if this life is so beautiful?" I'm sorry, I'm just sharing with you this because I would like you to know that my children had a good life in the United States. They attended one of the top schools in the nation. And before all this idea of divorcing came up and the kidnapping, I have concerns about my wife's mental health. She collapsed in the parking lot of our children's school and was taken to a psychiatric hospital where she was retained against her will and put on strong antipsychotics. After she was released, she described to me that she said there that she was sick because of her boss, so that all the guilt will go on her boss' shoulders, because she fought with her boss and she resigned to her job. A mother of 3 children one day came to my house saying, "I resigned." And I said, "What happened?" "Well, I had a fight with my boss, and I told her I don't need her job." We were actually in that time making the same amount of money. We had to pay credit cards, a mortgage, 2 cars, private schools, and my salary would not suffice for all that. And she knew that. But she refused. She just resigned to her job. That's indicating how she was mentally. She raised accusations against some of our children's teachers, neighbors, pediatrician, dentist, and other people. 1 year prior to the abduction, she went to Slovakia, supposedly to rest. But later on, she emailed me saying if I could come quickly to Slovakia to pick her up because she could no longer live under the same roof with her parents. According to her, everybody in the village where they lived looked at her as she was a criminal because of the complaints her father, Mr. Alexander Kish, had made against her. Department of State, Office of Children's Issues. I would like to express my gratitude to the Department of State for having assisted me from day one. U.S. Embassy officials attended each and every hearing in Slovakia. They sent diplomatic notes and demarches to the Slovak government and had personal meetings with government officials. However, as we all can see, although this tremendous work done by the Department of State is very much appreciated, after almost 7 years, my sons have still not returned home. This is showing us that much more needs to be done. The Department of State could use the additional tools provided by the Goldman Act in order not to let Slovakia find excuses to release its responsibility by saying that it no longer has jurisdiction over my children's Hague return case, forgiving my wife for removing our children to Hungary in violation of a travel ban, and staying the proceedings in Slovakia. We are not telling Slovakia how to rule their judicial system, but we are demanding Slovakia to follow the rules of treaties for which Slovakia has signed a membership, with all the respect to Slovakia. Specifically, the Department of State could take the following actions, as we all know: delay or cancel bilateral working, official, or state visits and student exchanges with Slovakia, withdraw, limit, or suspend United States development, economic, or security assistance. In summary, the Goldman Act not only empowers the Department of State, but it even requires punitive actions against countries that do not respect international agreements like Slovakia. Acknowledgements: I would like to express my gratitude to the Department of Justice, FBI, and Interpol, especially to Senator Cardin and Congressman Elijah Cummings for their support. To Mr. Ausias Orti Moreno, who is here, my children's case manager from International Social Services, and to the National Center for Missing and Exploited Children, who has been helping me from day one, especially to Rami Sar, Sarah Baker, Team Hope Program Director Abby Potash, all present here. To all my friends, members of church, colleagues from work, from Hopkins, my lawyers, they have left their jobs today to be here with me. My very special thanks to you, Chairman Smith, and your counsel, Alison Hollabaud. I would like you to know that when I spoke to my children over the phone, just shortly after the abduction, they naively asked me, "And Daddy, can you help us return home?" My heart breaks every time I remember these words. I promised my children then that I was going to do whatever was only possible in the world to help them. During these past 7 years, I have been working with lots of people, but one thing I can say about you, Chairman Smith, is that I can sense that you have sincere compassion for our children. You indeed care for the well-being of the children who are victims of all kinds of abuse committed by their own parents as a result of their blind selfishness. Abductors put themselves first. Children are secondary and often used as an act of revenge against the spouse. But this is why the law exists. What would the world be today if there were no laws? So on my behalf of my 3 boys, thank you, Mr. Smith, for creating the Goldman Act. Thank you for asking the Department of State to enforce the Goldman Act and request Slovakia and all the other countries who today are still attempting to bypass the law to go ahead and simply fulfill the law and return our American children. We did the same for them. When a child was kidnapped to the United States by a parent, our authorities made sure the child was safely returned to the left-behind parent in Slovakia. We did not create excuses. We acted fast. And we used all the possible resources, and we'll do it again. I know that I have very short time, but just one paragraph to my children. To you, Orko, Amaru, and Raimi, this is the first time I have given the opportunity to talk to you since our phone conversations were cut in 2010. I love you guys with all my heart. You are my life. I miss you. Every morning when I get up, I kneel and pray to God to help us to be together again, to protect you from any evil. I kiss your pictures that I have placed on the door of the fridge. I kiss your picture on my cell phone. I dream about you often, but I see you in my dreams still little. As you left our home almost 7 years ago, I bet you are bigger and stronger today. Hang in there, guys. Stay strong. God loves you more than anything in the world. I live only for you. Forgive me for not having been able to honor my promise to help you return home until today. And please, now read my blog. Read the court orders. I will put them all online. Read the news. Please give me the chance to tell you my part of the story, too. Every story has two sides. You have heard only one side. No matter what you have been told about me, please listen also to me. You guys also pray to God all the time, and pray for your mother too. God doesn't do anything wrong, but He only permits bad things to happen. I am waiting for you and will always be. Te amo, Orko. Amaru, te adoro. Raimi, I love you, Papa. Thank you.
Dr. Versace, thank you very much for your testimony. It is very moving, and hopefully it will soon result in the return of your children, and we'll do everything we can.
Thank you very much.
I'd like to now ask to present his testimony, Mr. Jagtianyi, and thank you for being here.
Thank you, Chairman Smith. Honorable Chairman Smith, members of the subcommittee and Congress, thank you for giving me the opportunity to testify before this committee today. I wish none of us had to testify on an issue like parental child abduction, but given the serious humanitarian crisis affecting thousands of children and families in America and around the world, I feel privileged to be able to speak about my daughter's abduction from her home in Mumbai, in New York, to Mumbai, India, and the challenges many other left-behind parents and myself have faced in securing her return home. Chairman Smith, with your permission, I'd like to submit my full testimony for the record. Thank you. My testimony today centers around our children. They are a product of love, and during their development, it is critical for our children to receive the unconditional love of both parents. Even if the parents decide to part ways, it is wrong to rob a child the love of and access of the other parent. Any problems that occur between a mother and father as they part ways have to be worked out in an orderly fashion through court in the home jurisdiction. Abducting the child and using them as a pawn for revenge or as leverage is incorrect and unacceptable. In my case, my daughter Nikita was abducted to India, a non-convention, non-bilateral country, in September 2013, when she was only 4 years old. Nikita didn't know she was being abducted, nor could she have prevented her own abduction. This is a stark reality of international parental child abduction, IPCA, which many governments around the world, including India, fail to acknowledge. Today, India has new leadership, and it is my hope that the new leadership will see this as an urgent problem and tackle it in the right way, so that these cases get resolved. Just as the US has had a civil rights leader in Dr. Martin Luther King, India had Mahatma Gandhi. Both these leaders had human rights and social justice at the forefront of their campaigns. If Gandhi were alive today, he would support India's accession to the Hague Convention on Civil Aspects of International Parental Child Abduction. At the time of the abduction, my wife and I had been living separately, but we shared custody of Nikita, who had just been enrolled at a new school on Manhattan's Upper East Side for the academic year 2013 and 14. My daughter was abruptly removed from school by the mother, citing a family emergency. Nikita's mother took a leave of absence from her job, terminated her lease, and traveled to Mumbai, India on a one-way ticket, coincidentally on the very day my dear father passed on in India. I happened to be visiting my ailing father in Mumbai at the time, and after his final rites and mourning period, I returned to my home and my job in New York. My estranged wife, meanwhile, announced that she would not be returning, nor would she permit the child to travel back with me. She had unilaterally decided to relocate to Mumbai because she claimed her career prospects looked brighter there, and she alleged Mumbai was her birth and matrimonial home now. Nothing could be further from the truth. She is a U.S. citizen who abducted a U.S.-born and raised child, both of whose habitual residence was in New York. My estranged wife was attempting to move the playing field to a favorable forum and using our child as a pawn to gain from her wrongful act. It was a sinister plan, and I vowed to fight for my child's rights. On returning to New York, I heard from her friends that she had been planning this abduction for months, so I immediately consulted a lawyer and initiated a wrongful removal and custodial interference complaint. Due to the challenges by the abducting parent, it took me 18 months to complete service in India, upon which she became party to the custody case in New York. The court conducted a detailed investigation. I was awarded temporary custody, and my estranged wife was directed to immediately return Nikita to New York. Of course, she has not complied. As a result, Nikita's mother has been charged with kidnapping by the federal prosecutors in the Southern District of New York. A battle is won or lost by choosing the terrain on which it will be fought. While thwarting service of New York proceedings and orders, Nikita's mother embarked on a series of malicious and civil and criminal proceedings in India, not only against me, but against members of my extended family. With an array of favorable laws and an extensive support base in India, Nikita's mother has relentlessly pursued a slandering campaign in multiple courts and multiple jurisdictions. Jurisdictional arbitrage is the practice of taking advantage of discrepancies between competing legal jurisdictions, using whatever tactics and loopholes imaginable. For those on the receiving end, India can feel like the wild, wild west, and abducting parents in India play a nefarious game by filing false, unsubstantiated criminal charges in India, while in my case, use the local police to harass my extended family. Interestingly, India is a signatory to the Hague Convention on Service of Process of Judicial Documents, a founding member of the Hague Conference, but is not a signatory to the Hague Convention on Civil Aspects of International Parental Child Abduction. This has resulted in unnecessary hardships, wrongful separations of children from their loving parents, legal delays, and prohibitive costs. Challenges in India. Based on recent press reports, more than 27 million cases are pending in India's district courts, 6 million of which have lasted longer than 5 years, while another 4.5 million are waiting to be heard in the high courts. A former esteemed Supreme Court Justice of India, B.N. Agarwal, stated, delay in disposal of cases, quote, delay in disposal of cases not only creates disillusionment among the litigants, but also undermines the capability of the system to impart justice in an efficient and effective manner. Abducting parents and their aiders use India's systemic delays in the judiciary as a tool to benefit from their wrongdoing, seeking to delay or deny the return of abducted children to the countries of their habitual residence. Left-behind parents face other major hurdle. India's institutional bias against recognizing parental child abduction as a violation of human rights and law, and gender stereotypes which manifests itself in various forms. Indian judiciary and policymakers view international parental child abduction not as a child's rights issue and legal violation, but rather as routine child custody issues. When a mother perpetrates child abductions, they often treat these cases as women's rights issues. The result being Indian court routinely relitigate divorce and child custody cases decided by competent courts in other nations where children habitually resided, thus creating a complex legal web. When mothers of Indian origin, regardless of their nationality, abduct children to India, they are often viewed as helpless women or abla naris who cannot legally defend themselves in a foreign country and hence need protection in Mother India. When a father abducts children to India, left-behind mothers often face other forms of gender bias. Left-behind mothers are asked by Indian courts to return to India to fulfill their duty to their children and spouses. Often, Indian courts usurp jurisdiction and issue arbitrary orders without framing of issues or examining evidence that then become cumbersome to remove. Ex parte interim orders are often issued without due process, lingering for years, compounding the pain for the seeking parent and the child. When a mother abducts children and flees to India, there is a whole cocktail of legal procedures to avail of, and numerous nefarious operators to advise them. Two of the most commonly misused and draconian laws are related to the Protection of Women Violence Act, 2005, and Section 298 of the Indian Penal Code. While the intent of many of these laws may be good, quite often during implementation, the spirit is lost when the lines get blurred between allegation, fact, imagination, and reality. It is no wonder that parents, regardless of gender, who abduct their children to India find safe haven under Indian laws. In all cases, children are the innocent victims of a crime that India refuses to recognize. My family and I are victims not only of IPCA, but of India's legal system, which is failing to deliver justice. My daughter is an innocent, voiceless victim of a crime committed by her mother, aided and abetted by India's refusal to recognize IPCA as child abuse, a human rights violation, and a crime. I am left with no choice but to litigate in a broken legal system and a cross-border legal vacuum, trying to reunite with my only child, my daughter Nikita. For the last 3 years, since the passage of the Goldman Act, we at Bring Our Kids Home have been tirelessly advocating for the Indian and US governments to work together to address the pain and suffering caused by the lack of legal framework that deals with this serious and growing issue. For our part, the many left-behind parents have successfully obtained US court orders establishing our children were habitual residents of the United States and were wrongfully removed from the United States or retained in India. Starting in December 2012, the Department of State has sent formal written requests to India's Ministry of External Affairs, and our government has engaged with the powers in India to provide a common-sense solution to have our children returned. However, the State Department, the Department of Justice, and others have failed to convince our strategic partner, India, to cooperate with us in the return of American children. The institutional and systematic complacency in India and the lack of urgency by both our governments to decisively address this serious and growing issue only hurts our children and our national interests. We are a rule of law-based society, but when it comes to international parental child abduction to India, there is no rule of law. During Prime Minister Modi's visit to the US in June 2016, we were pleased to note that the issue of international parental child abduction was raised in the strategic dialogue and was part of the bilateral statement. Quote, recognizing its mutual goal of strengthening greater people-to-people ties, the leaders intend to renew efforts to intensify dialogue to address issues affecting the citizens of both countries that arise due to differences in the approaches of legal systems, including issues relating to cross-country marriage, divorce, and child custody. Shortly after we saw reports that the Ministry of Women and Child Development, MWCD, posted a draft bill for India's accession to the Hague Convention on Child Abduction on their website, the draft bill, and we were hopeful and excited to witness progress. Bring Our Kids Home provided feedback and comments to help guide a fair and common sense solution for our kids. Early in the fall of 2016, we heard sound bites that the vested interests in India, including the National Commission for Women, prominent women's rights attorneys, and abducting parents, were lobbying to maintain the status quo and convince the Ministry of Women and Child Development to oppose its own draft IPCA bill. Sure enough, by Thanksgiving, we received news reports that they had junked their draft IPCA bill and would not sign the Hague Convention. The reason stated being, we found that there are more cases of Indian women who return to the safety of their homes in India after escaping a bad marriage. Cases of women who are foreign citizens married to Indian men going away with their children are far fewer. Hence, signing the Hague Convention would be a disadvantage to Indian women. Also, a majority of such cases pertain to women instead of men running away, said a Women and Child Development official. As you can imagine, we had a pretty dismal holiday season without our children and being robbed of our hope of any solution at all. 5 weeks later, on January 3rd, 2017, we saw a report that India will reconsider their hasty decision and invite all stakeholders to a meeting on February 3rd, 2017. As important stakeholders, we reached out to the Ministry of Women and Child Development through multiple channels, only to be informed that this would be a closed interministerial meeting, and the MWCD suggested we participate via Twitter. After pushback from several left-behind parents on Twitter, the ministry tweeted an email address in a couple of days before the start of the consultation, but would not disclose the precise time and venue of the consultation, which would be a significant impact to the lives of our children and families. Bring Our Kids Home and several left-behind parents emailed our concerns and suggestions to the ministry to consider during the IPCA Hague consultation, held on February 3rd, 2017. Based upon independent sources who attended the consultation in New Delhi, we were informed that mothers who had abducted American children to India were at the consultation and even presented at the event. However, no representation from left-behind parents was invited. I was aghast to find out that amongst those who presented at the Ministry of Women and Child Development consultation was my estranged wife, who made a detailed presentation on why India must not accede to the Hague Convention on Child Abduction and presented a perverse narrative on IPCA. Thus, over the past several months, left-behind parents have been on an emotional and psychological roller coaster, while the government of India gives mixed signals at best, and the US government offers no substantive relief. Left-behind parents across the spectrum feel like we are fighting a David versus Goliath battle, and our administration isn't pulling its weight in this fight. Before I conclude my testimony, I'd like to make a direct appeal to Prime Minister Modi, to Foreign Minister Swaraj, to Minister Maneka Gandhi, and to policymakers and judges in India. Instead of dehumanizing us left-behind parents who have had our children taken away from us, been robbed of the love and affection of our children in the best years of their lives, most often being denied any access, and in my case, the abducting parent will not even disclose the physical location of my child in Mumbai. It is heartbreaking when I receive a message from my Indian attorney the morning of a scheduled Skype call with my daughter that she's too busy with her friends or her activities to come to the phone or the computer to say hello. This could happen to anyone. Imagine it was your child. Please engage with us, not symbolically, but as important stakeholders, and allow us to participate in creating a fair and just policy so that no parent or child has to go through this trauma we have endured. In conclusion, I respectfully ask you, Chairman Smith and members of Congress, is enforcement of U.S. law optional? How long should we, parents of America's stolen children, wait for our government to enforce our laws and hold perpetrators accountable? How many more hearings do we need before countries like India, Japan, and Brazil be held accountable for their lack of cooperation in returning American children? We have a new president who puts America first. I urge President Trump and our federal agencies to enforce the Goldman Act and put America's children first, above other bilateral priorities. With Prime Minister Modi's possible trip to the U.S. in May of this year, I respectfully urge President Trump to use this opportunity with Prime Minister Modi to resolve this issue as a bilateral priority and usher a new era of bilateral friendship between our two countries. Please help bring my Nikita back. Please help bring all our children home. Thank you.
Mr. Jaityani, thank you very much for your testimony and for your appeal to Prime Minister Modi. When he was here last year, I actually introduced him to one left-behind parent, a young woman whose two sons were abducted, and asked him personally to intervene. I've met with the ambassador. There's been pushback on all of these cases, which is deeply troubling. And my first question will go to the whole issue of, the Goldman Act provided a very, I believe, effective framework, but it requires faithful implementation. We got less than adequate implementation under the Obama administration. It is unclear whether or not President Trump will faithfully implement it. I hope and pray that he does. When he met with Prime Minister Abiy, we sent a detailed letter to him before that meeting regarding the left-behind parents, the older cases, as well as the new Hague cases, both of which are being inadequately cared for by the Japanese government. And I would just point out that in 2011, when I went to Japan with Nancy and Miguel Elias on behalf of their grandchildren, Jade and Michael, we met with the Minister of Foreign Affairs. He was then the Vice Minister, Matsumoto, and he was very empathetic. We found empathetic ears, but not empathetic actions on the part of individuals. The Eliases now are, many years later. The abduction was in right before Christmas in 2008, and so many other of the longer cases have been agonizing beyond words. So and then last year, a couple years ago, at the first oversight hearing of what OCI was doing in terms of its report, it was an embarrassment. How poorly crafted the report was, how it left out critical details and information, so bad that they went back and said they would redo it, and it came back better, but certainly not covering the fullness that we had hoped that they would. In 2016, for example, the report, Japan was not listed as a country demonstrating a pattern of noncompliance, despite the fact that it had hit all of the criteria that should have put them on that list, which would have then led to the hoped-for sanctions to sharpen the mind of our friends in Japan. And they noted that there was a problem with enforcement of return orders, exactly what Mr. Cook has raised to us today. Enforcement of Goldman is first. That we can do. And Goldman was not enforced by the Obama administration, and I find that to be a missed opportunity. And for all of you, it must be agony beyond words, because there were tools that were unutilized and remained in the toolbox. Dr. Hunter, you had a successful case, thank God, and we have 3 ongoing individuals whose cases remain unresolved. One of the points we put in, so I would ask all of you, first the report has to be done right. The April 30th deadline has been missed before. Last year it was 72 days late, and frankly, I would rather have lateness and tardiness than an inadequate report. So my hope is that they will get it right this year, and Japan certainly jumps off the page. India needs, I think, a much more robust response once it is so designated as a non-compliant country. So getting it right on the report, and Dr. Hunter, you might want to lead off on that. You know, one of the things that I found appalling was a pattern with the last administration in not speaking truth to power. I also authored, besides the Goldman Act, the Trafficking Victims Protection Act. And that requires a report every year that lays out countries along a tierage system, Tier 3 being egregious violators. Well, 16 countries were improperly given a passing grade by the Obama administration. And I'm not saying here what I didn't say then. I had a series of hearings at which we said, how could you falsify the report on sex and labor trafficking to give Malaysia, Oman, China, and other countries, Cuba, a passing grade because of other political considerations? The report has to get it right and state clearly and without any ambiguity where the country stands, list the cases honestly, and I can tell you if the report comes out inadequate again, no matter what comes out in the report, we will have a hearing on that to hold whoever the new person is to account and to encourage that at least get the report right done first, and then the sanctions regime and enforcement and the imposition of penalties will be part 2, which is the way the law designed it. I'm very concerned as well that there was no MOUs. When I was in Japan with the Eliases, we raised with our ambassador, with our delegation there. The ambassador was out of the area then, but we raised it repeatedly since, and with every other country where there are individual left-behind parents who, when a Hague, for example, was entered into, are left behind a second time, because obviously Hague is from the date of ascension, and anyone before that is not covered by Hague. So we have pleaded with the Obama administration to enter into MOUs with countries to figure out a mechanism to get those children back home to their left-behind parents. Not a one. Not a one. We also wanted that also for countries that are not part of the Hague Convention, because obviously there needs to be a durable mechanism for effectuating the return of those children, and you need a systematized system, to put it the bottom line in, to make that happen. And so I'm very, very concerned about that. But I have brought up, and when Prime Minister Modi, if he does come again, that will be, hopefully, that's something we will appeal to the administration to raise. So the idea of the report, MOUs, and this issue, and again, Mr. Cook, your idea of the G7 is a fantastic one. We'll circulate letters. I know that Allison brought that up earlier today at the meeting at the White House. I do hope that the White House, you know, of all things, when the theme that the Italians have put for this, citizen safety, well, how about the safety of abducted children? That should jump off the page. So I think that's and your thought of a G6, that was an interesting and very novel idea as well. So speak to the reports, getting them right. Again, I'd rather miss the deadline and get it right. They were 72 days late last year and didn't get it right on a number of countries like Japan. And then I'll yield to my friend and colleague, and we'll have some additional questions after that. Dr. Hunter.
Thank you, Mr. Chairman. And the reporting is essential for a few reasons. One, transparency is important for us as parents who have been advocating for this. So in my professional capacity, data drives our decisions. I work for the Kentucky Office of Highway Safety. We use data about driver behavior, vehicle miles traveled, fatalities, serious injuries. We rely on data to address the solutions and to drive our solutions. And so it's very, very important that we aren't, in my professional capacity, doing what we think needs to be done. We're relying on good quality information. And that is something that we have been for some time asking the State Department and the Office of Children's Issues for. Part of that, we had begun to take it into our own hands, and we are trying to collect data from parents to help us to fully identify the scale and scope of this problem. We were very pleased at the White House meeting to learn this morning that there are indeed mechanisms and analytical tools that are available. So we're hopeful, and from ISTAN's position, there's not much that can be done about what has happened. What we can do is look at a way forward. And for us, the ability for the State Department to clearly, accurately, honestly, and with integrity report on the full scope and scale of the problem is essential. And I would venture to say that once there are true numbers out, that will mean great things for Congress and your ability to effectively advocate for your constituents as a casework function, but then also to effectively engage with nations. But we can't know any of that until there is proper reporting. And so we do call upon the State Department as they issue the next report to make sure that the information is reliable and it's consistent. And it does, if it is reliable and consistent, these worst offending countries are going to rise straight to the top. We're going to see Japan as non-compliant. We're going to see Brazil as non-compliant. We're going to see India as non-compliant. Even the countries that aren't signatories, if the information is reported accurately, the United States will be in a position of strength. The President will be in a position of strength when he engages with these nations to effectively advocate for American children. And if I might just very briefly say on MOUs, memorandums of understanding, or other types of agreements, these are essential. It's our understanding that this administration has, for all intents and purposes, thrown out the playbook about how it has been done in multilateral agreements and multilateral treaties. We're in favor of that. We're in favor of the United States negotiating directly with every single nation individually and from a position of strength. We have many, many tools in our arsenal in the Goldman Act to require countries to return our children, and I think that there ought to be both that dialogue, and that has its place, but yes, strongly worded memorandums that make it uncomfortable for countries. Thank you.
One of the ideas I've scribbled down here, and that might be what? Oh, you can't hear me? Okay. Is little note is I left it out of my testimony, but it would be wise and would make a statement if the State Department were to come out and issue a travel warning, specifically for the country of Japan, and as the United States, indicating that we do not recommend anybody, any children of half Japanese descent, or anybody that has a child of that, to travel to the United States at any point, because to circumvent the Hague, the latest gimmick, if you will, is what is happening, and is that let's say a Japanese spouse will play all nice and say, can we just go visit my family in Japan? Okay, let's just take a vacation, which to a compassionate and understanding, U.S. citizen might say, sure, let's go visit the family. Once you're in Japan, it's done. She can have you arrested, or he, excuse me, but it's mostly women, so put it that way. She can have you arrested, and as we know, too many cases of people that get held, for 23 days in the Tokyo hotel, and other things like that. And so that one sends a statement, symbolic. Two, it's a very practical sense, because people are being good-hearted, compassionate people are being hoodwinked into returning with their children to Japan, and at that point, they're just like this individual from Italy. He went back, and everything turned suddenly, and there's nothing that can be done at that point, because we all know Hague is ineffective once you're in Japan. So,
yes, Chairman Smith, we thank you so much for your efforts, in engaging with India's leaders on behalf of Bindu Phillips, and with Prime Minister Modi and the Indian ambassador. We heard you used to get him in the halls of Rayburn, and we thank you so much for that. And actually, Bindu is in India right now, I think, visiting her kids. After 8 years, she got an order from the Supreme Court of India to be able to see them, and they've now actually aged out of the system, which is really pretty tragic. As I was actually talking to Dr. Hunter off the record, one of the issues with India is, we have to effectively we have to, we're dealing with cultural biases, and we have to change the thinking before we can solve the problem, really, and it's a long haul, but I think with the tools within the Goldman Act now, soft diplomacy might not work as well, so we need to do something to really get them to take some action on our orders here. And it is my hope that President Trump, who is a family man, will take cognizance of this issue in the upcoming visit, and we will see some resolution. So, thank you, sir.
Mr. Garrett.
Thank you, Mr. Chairman. It strikes me, and I'll tell you by way of background, that I spent about 10 years as a criminal prosecutor. And when I finished law school, I swore never to do domestic law. I would rather try a murder case. And I mean that, and I don't mean it to be funny. A couple of times during the testimony today, Mr. Chair, I had very itchy eyes that needed wiping. The circumstances are just heartbreaking. I want to commend the folks who came, I believe, probably with Dr. Frasancho. You obviously have a good, strong support network, a lot of people here on your behalf. It strikes me that perhaps wording as it relates to the status of your respective children might get in the way of messaging. And what is beyond my ability as a father and a divorcee of 2 children to wrap my brain around is not that you don't have custody of your children. And I'm going to tell you how I feel, not perhaps what you want to hear. It's that you're not able to see your children. And as I think through this process in my limited tenure here, Mr. Chairman and members of the panel, I try to think about what outcomes are possible. What can we get to? And so what I will promise you that our office will do is reach out specifically, starting with Japan, to the ambassadors and embassies and start to ask questions. And I say starting with Japan because obviously Slovakia and Brazil and India are other nations of note. But my questions won't be driven towards gaining custody of your children. It will be driven towards gaining the right of you to see your children, right? Because there's 2 sides to every case. The court can come to whatever conclusion it wants, but to deny you the right to even see your children is beyond my ability to wrap my brain around. It's a grave injustice, not only to yourselves, but to your children. Dr. Hunter, you talked about the scope of the problem, and there's a handout up here that we haven't received. I'm going to ask if our office can be made privy to, but I want to wrap my brain around that. If you all have amalgamated data on what countries have how many U.S. dual citizen children residing, what is the scope of the problem? And I don't know if there's an answer to that, except for I'm asking for your data so that we can sort of wrap our brains around it. Do you know a number off the top of your head?
We know numbers, but we are concerned about the accuracy of those numbers, and we truly believe that they have been lowballed, so to speak. The State Department reports that every year about 1,000 American children are abducted and taken to a foreign nation, where it's a fight to bring them home. However, we suspect those numbers are much higher for a few reasons. One, many parents don't know that they need to report. They feel when their child has been abducted that either if they can't solve it themselves, there is no hope. And so we know that there are probably cases in which children don't report. We have been able to quantify the numbers, and we like to look at this from a whole number perspective. So over the last 5 years or so, we can imagine that over 5,000 children have been taken. My colleague, Jeffrey Morehouse from Bring Abducted Children Home, they often indicate that over the span of the time that the Office of Children's Issues was established, 29,000 children have been abducted, and a fraction of those have come home. But to your answer, Mr. Garrett, we don't know, which is why I'm actually optimistic that now that we know that the State Department has this reporting ability, perhaps we can get more accurate numbers. And there are many data points that we could parse out of that.
Well, a number obviously is a number, but a name and a face are compelling. And so I would encourage you, and I'll work with the chairman to try to, and obviously there are privacy concerns, we're dealing with minors, but at least as it relates to the specific members of Congress, compile a list. I would love to know the names, dates of birth, and nation and nationality or dual nationality status of the young people from my congressional district. I encourage you to send to each senator and congressperson the list of, because names and faces make people move.
Sure.
Numbers are scary, but I'm asking if you guys can do that starting with us, and that'll help us have a jumping off point. Not that someone by virtue of living in my district is any more important than any of you, but we have a limited amount of bandwidth. Mr. Cook, you talked about the legal process in Japan. I'm vaguely familiar with the barriers to entry to the legal profession in Japan, and suffice it to say, we have an awful lot of lawyers in this country who might not be practicing law if they were subject to the requirements of the Japanese bar. It can't be cheap. Do you have a dollar figure? I heard 96,000 at some point.
Well, with respect to the situation going in Japan legally and culturally, there's several things that I can't disclose or say.
How much have you spent? And if you can't disclose that, that's fine.
It is a lot.
So what I'm driving at here is,
I quoted a $95,000 figure. That is sometime in history. That's not a current.
right, so what I'm driving at here, and there's bound to be a cottage industry in the legal profession in Japan of people who represent foreigners who have children in Japan.
Yes.
And I don't begrudge them, although I think they owe you a duty of forthrightness on the front end, that it's a tough system and that the results aren't guaranteed. What I'm driving at here, though, is that if you're not able to earn the amount of money required to fight the fight that you are fighting, you got nothing, right? I mean, and that...
Well, Mr. Garrett, here is a case in point. I am virtually without financial means anymore. And after a year of trying to enforce the return order of the Osaka High Court of over a year ago, that drained significant assets that I had. In fact, lost our house in the process. Okay. Well, the loss of the house and my drained financial resources was used as the primary rationale for the Osaka High Court to revoke their order of return because he has no money. Why would we send him back to America? And that fundamental, so in essence, they just wait you out. They want you to quit legally, financially, emotionally, spiritually, and that has been allowed to occur primarily because we've had a Department of State unwilling to use the Goldman Act tools that it's had. Additionally, and this comes informed from, well, actually, to one little thing I note, to a view, since you come from a legal background, a view to the enforcement in Japan, and I use the term enforcement loosely, every step of the way, for me to have, first of all, to have access with my children, I require the abductor, my wife's permission. In order to do the direct enforcement, or you do the ambush, we needed her permission to do it that day. So, I ask you, what do you think the likelihood is I'm going to have access to my children if the legal foundation in Japan requires the permission of the abductor to allow me to do it? And there is no body to enforce that. And so Japan will be in indefinite non-compliance with the Hague.
Have any of you on the panel had any contact, even via telephone or mail or email, with your children, or is it just radio silence, to use a military sort of cliche? Has any, Mr.
Yes, sir, I have actually. There was a court order for me to get Skype access. Initially it was phone, then they escalated to Skype, which I got, but that's been discontinued now of the last.
Well, again, I pride myself on not telling people what I think they want to hear, but the truth. And I will tell you that you've enlisted a warrior for your cause today in the form of myself in our office, but my goal is not to fight for you to receive sole custody. My goal is to fight for you to receive access, because the courts will arbitrate who the custodial parent is, what have you. But I can't fathom that you have no access.
Yep.
And I think that it requires the light of day be shown on these circumstances, and that the Fourth Estate be enlisted,
Currently,
and that we shame them, if you will, into simply allowing you access.
currently in Japan, there's an evolving, I'll call it a scandal, and I'm going into the heading called Shelter Net, that I can't get into the details of too much because it's not my country, but it is being slowly handled. And I alluded to it in my testimony about there are forces within Japan that are doing their level best to make sure Japan does not change one iota from the sole custody zero-sum game, and also to make sure that they will not comply with anything in The Hague. And those people, those individuals are peppered all throughout the judiciary and the legal system. And so to shine the light on them is not going to do much. Because and I'm being maybe imprudent by talking about it now. I would like to have said a lot more in my letter to my children, but I've been advised that I have a very, very narrow scope of what I can say, because when it does get over to Japan, it will be spun in such an egregious manner that even my testimony here today will be cast as some out-of-control, violent, rageful individual.
Well, that's not what I've seen. Mr. Chairman, I thank you for your latitude as it relates to my questioning, and I sincerely ask each of you to reach out to our office with your specifics. James Vandenberg's here with me today, and we'll be working on this subject matter. And again, I think a realistic goal is that you should receive access to your children. It might even be that you have to travel to them, but by gosh, that's not a big ask. That's not a big ask. And as a father, again, I can't wrap my brain around what you all have gone through. So,
Mr. Garrett, may I offer one other piece of information? The Goldman Act certainly does require the State Department to report to you and every member of Congress the children who have been abducted and withheld or wrongfully retained in another nation. We will certainly get with your office and James to help you identify cases, but you should be receiving this information also from the
at the
State
risk of
Department.
angering the State Department, I find that I receive more forthcoming good information from private citizens than the State
Yes, sir.
Department.
I agree.
If anybody from states here, I apologize. Thank you, Mr. Chairman.
Thank you, Mr. Garrett. Let me just conclude with a few final state comments. First of all, I want to welcome back Ravi Parmar, who is from my district. He's from Manalapan. His son was abducted to India 4 years ago. He has previously testified and gave very, very insightful testimony. And again, like so many others from India, his case remains totally unresolved. And so it's highly, not just disturbing, it needs to be changed, and certainly our hopes are rising that this new administration will do it. The tools are there. I'll give an example, Dr. Frashancho, your case, Slovakia is trying to make, as you know better than anyone else, make you begin your case anew in Hungary because of the proximity of where the children are, right next to Slovakia. And yet, the State Department, in the 2016 Goldman report by the State Department, suggested that Slovakia is proof that diplomacy works. And notes in 2015, and I quote, U.S. Ambassador to Slovakia joined with chiefs of mission from the French, Irish, Italian, Spanish, and Norwegian embassies to address problems that parents experience with the legal system in Slovakia, including a lengthy appeals process and difficulty enforcing Hague Abduction Convention return orders. The Slovak Ministry of Justice introduced new legislation that entered into force on January 1st, 2016. The legislation set a 12-week time limit for the resolution of convention cases, limits the number of appeals, and provides for expeditious enforcement of convention orders. Didn't apply to you. You were not, found no remedy in that. Matter of fact, ironically, the new limit on appeals is actually preventing you from appealing Slovakia's decision to close your case and to move it to Hungary. For its part, the U.S. government is refusing to get involved in, quote, legal matters. That's an abandonment of you, frankly, and I apologize for the State Departments for doing that. Yes, there are some very good Foreign Service officers that take these cases seriously, work hard on them, and I applaud them and have singled them out over and over again. But time and time again, without an MOU, without vigorous enforcement of Hague, where Hague is in force, and without the penalty phase prescribed in the Goldman Act, these countries, like we saw with the foreign minister of Japan, they go to their parliament and say, you know, the Americans don't enforce their own law. There has been no sanctions meted out to any nation under the Obama administration, and that has got to change with this administration. So Doctor, you might want to speak to that if you'd like, but it seems that what a twisted way of applauding a country, and yet you have been so further penalized by even a law that we lift up as being a good one.
Yes, Chairman Smith. The truth is that my wife and her parents, they live in the border between Slovakia and Hungary.
Right.
It's only 40 miles, the distance from the house in Slovakia to the school that the children attend in Hungary. She holds 2 jobs. She works in Slovakia and in Hungary. It's like keeping one foot in each country. I think she is hoping that we are going to transfer the whole litigation to Hungary. And once Hungarian judges decide that this is wrong again, and the children have to return back to the United States, I think she believes she can go again to Slovakia. And it is just this game, like ping pong. I have explained all this to the State Department years ago, and I have met with a couple of officials from them, and they have told me, they have advised me that it would be good to start a new case in Hungary. And I have repeatedly said that I don't think this is the best idea, because how can we start a new litigation in Hungary when Slovakia has accumulated evidence for 6 years? That just doesn't make sense. I also would like to know that my Slovakian lawyers, one of my Slovakian lawyers advised me and said, Dr. Frisancho, I am a Slovakian citizen and I know how our people think. If Slovakian authorities are getting these demarches, diplomatic notes and whatever from the US Embassy, that's not going to work. You have to ask the State Department to directly contact the Minister of Justice or someone in Slovakia at the highest level. I have repeatedly said that to the State Department for years, and my case managers have always answered, we have to escalate. But we are escalating for years, and we never got to the top. As I said before, I am very grateful for what they have done for me and for my children, but we all can see that nothing of this works. So if I could ask one more thing from the State Department, it would be to follow the instructions of a Slovakian lawyer. That's a Slovakian citizen. He knows what he's saying. He understands the Slovakian mentality. They are not going to listen to these diplomatic notes, personal meetings, demarches. They are upset, of course, that Slovakia has appeared on the report of non-compliance. They are upset, I am sure, that they lost the case under the European Court of Human Rights. They had to pay me damages. With that, they had to acknowledge that they did wrong. They violated my human rights. But the case is still pending, and it's because we need more pressure from the top.
I think that point is well spoken, and I thank you for it. You know, there are others in the audience. Jeffrey Morehouse was mentioned. Adina Barbaro, who testified some years ago, last year I believe it was. She has an unenforced order, like so many others. And if there ever was an Achilles heel, there are lots of them. It is the unenforced order. You know, you get the piece of paper, you think, I got it, and then it's not enforced. And so, again, I think this is the first hearing this year on child abduction. It will be followed by several others, including inviting the Trump administration to send its top representatives here. And I hope the same thing happens on the Senate side, to begin an all-out effort to enforce the law, the U.S. law. Find if there needs to be any additions to it, but above all, enforce what we got. We do have, it was painstakingly arrived at. I introduced it 5 years before it was actually enacted and went over it multiple times, always looking to finally tune it. The Senate wouldn't take it up, and then they finally did, thank God, and we were able to get it down to the President for signature. But again, a law that's unenforced is certainly it's just sitting on the table. We need enforcement, and that's going to be my mantra going forward, I can assure you. Anything you'd like to add before we conclude? And I thank you again for coming forward, and I certainly, as a father myself, so deeply respect your love for your children, and all of us feel that way on my staff, that we're just in awe of your tenacity, of your love, So if there's anything you'd like to say, or we'll just conclude. Yes, Doctor.
I would like just to send a short message to all the fathers and mothers who are dealing with similar cases. What the abductor wants, and sometimes the courts in their countries, and all the authorities in their countries who are supporting the abductors, what they want is to wear you out. Please, stay strong. Find any kind of support in your church, your friends. You see how many people I got here today. You have to fight for your children and use us as an example. Look at Noel, James, everybody here, Adina, and Randy, and so many people. We struggle. We cannot sleep. We think of our children all the time, and we know what this means for you. So please, you have to keep going. Stay strong and fight. Your children will appreciate that one day, and you have to make sure that they know. Like my kids, I don't think they know. The National Center for Missing and Exploited Children just helped me to publish my blog on December 2010. For the first time, my kids had the opportunity to see something about me. When I went to courts, I almost never spoke anything wrong about my wife. The court proceedings took place mainly about her accusing me of everything possible, and me and my lawyers defending. But I changed my mind, and so from this year, I am going to start making all the real information public so that my children can see that. And I cannot just leave without continuing trying to help my children. It's nothing against the mother. I believe that there is a law, and we have to fight to make sure that those who are responsible have to fulfill the law. So parents, please, stay strong and keep fighting for your children. That's all what I wanted to say. Thank you.
Thank you.
Mr. Chairman, thank you. Just closing, few words from us. We truly do believe, again, that this is the time to put America first for America's stolen children. We expect this administration to hold true to that as it relates to this vulnerable population. Transparency is very, very important. Good data from the State Department reported to Congress you can use, and we as an organizing and growing parent community can use. We're not going away. More parents are coming along every day to believe that there is a solution, and the only solution is children returning home. And then we call for strong leadership in the Office of Children's Issues that would make this a transformative process. Thank you.
Thank you so very much. The hearing is adjourned.